If you were to become hospitalized and unable to voice your final wishes or were to pass away suddenly, does your family know your final wishes? Hello, my name is Kelly Morris, and today I will be persuading you as to the need for an advance directive. I'm going to be focusing on three main types of advance directives: the how-tos, or the steps on how to go about getting them legally executed, and how each one can benefit you and sustain your wish. According to www.in.gov, an advance directive is a term that refers to your spoken and or written instructions about your future healthcare treatment. Advance directives are normally one or more documents that define out who you want or do not want making your end-of-life decisions. If you become a patient somewhere, federal law does require that each person is asked if he or she does have an advance directive. However, I want you to note that you are not required by law to have an advance directive, and this is something we will touch on later on in the speech. The first advance directive that I am going to talk about today is called a do not resuscitate, or a DNR. This is a legally binding document that once it's been executed by yourself and your healthcare professional, that states that in the event of organ failure, heart, lung, that you do not want life-saving measures such as CPR or a defibrillator applied to you in an attempt to resuscitate you and save your life. In my experience, these are generally presented for major surgeries, hospital and or nursing home admissions. Note that even if this is your wish to not be resuscitated, and if you do not have a legally binding DNR per Indiana state law, you are treated as a full code. So regardless of what you want, if you do not have this document in place and you come in to the hospital, you will be given every life-saving measure unless they have this document. The next advance directive that I'm going to be talking about today is called a power of attorney, or a durable power of attorney. This document is specifically designated to a certain person to make sure that all advance directive wishes are carried out, that all financial decisions are made, healthcare options, and if no further documentation is on file, it also gives your healthcare provider, that person, the legal right to make your end-of-life decisions for you. So, for example, life support versus no life support. So if you don't have, for example, a DNR or something like that, or we'll get into some documents we'll get into a little bit later, then the power of attorney document then overrides and becomes sort of an umbrella for this. So that power of attorney that you have designated does have that right to say yes or no as far as whether or not you live or die, basically. The final advance directive that I am going to be talking about today is called a living will. This document puts your wishes into words in the event you become terminally ill and cannot communicate. This lists specific care or treatment you do or do not want during a terminal illness. This can include up to and including CPR, feeding tubes, a respirator, a ventilator, blood transfusions. In the state of Indiana, there are two living wills. One that states that you do not want life-saving measures done. It's called a living will declaration. And the second one is called a life-prolonging declaration. That one states that the healthcare provider that you see in an emergency situation or a scheduled situation, has the right to use all measures available to save your life. Legally, 2 living wills need to be carried out by 2 adult witnesses and signed by you or someone that's designated to sign on your behalf. So there are legal processes that need to be taken in order for these documents to be binding. And that is the key word, is that you can have these documents, you can have everything on file, but if they are not executed properly, they are not legally binding and they will not hold up. A healthcare provider or doctor will not go by them. The do not resuscitate, again, the doctor's order is needed with a signature. This, however, can be canceled verbally during any time if the treatment is not desired or if it is desired. So if at any time you're in a situation and you suddenly change your mind in the middle of having some kind of an episode, then verbally all you have to be able to say is, I want life-saving measures or something to that effect, and that will null and void your DNR. The power of attorney, this is a very specific document, more so than the other two. This specifically names a person, lists situations that gives the power of attorney the power. It lists the powers that you specifically want to give that person or not give that person. It must be in writing and signed by you in the presence of a notary public that is not a family member. It should be noted per www.ecommunity.com/patient rights that under Indiana Code 16-36, Indiana law can decide who makes your healthcare choices for you in the event you do not have an advance directive. This law will allow any immediate family member of your family, such as a spouse, parent, adult child, or sibling, to be contacted in the event something were to happen to you, and this gives them the power to make the decision as far as your life-saving measures or not life-saving measures. And that's if you are, like again, if I said, if you're unable to do so mentally, physically, verbally, this is what will happen if you do not have an advance directive. So in my situation, luckily I am close to my brother, I do have a spouse, so that would fall on them. For someone that is perhaps single and does not have very much, family, or if they do, are not close to them, regardless, those people are still the ones that get called, and those are the ones that have to make that decision. So that's just something to think about. I personally did not even know that any of these directives existed until between the years of 1998 to 2001. And then when I knew they existed, it took a while for me to fully comprehend them. At which time I did become the power of attorney for my father. He was diagnosed with Alzheimer's and was advanced staged early onset dementia. So he did not have any of these documents in place. My mother was schizophrenic, so therefore she was mentally incapacitated per Indiana state law to make the legal responsibility or legal choices for my father. And then my grandmother had passed at this time, so that ultimately fell on me because my father's brother had passed as well. So I was put into a situation that I really didn't have a choice other than to go ahead, have the power of attorney executed, do the right thing, and make I felt, proper decisions for my father and his health care. of course, consulting with my brother, but legally that fell on me. Um, at being such a young age, and for my father to not have this documentation in place, it it was it was difficult. It was hard for me to actually be able to focus on spending the time that I had with my father. So, versus doing that, I was out running around getting all this legalities taken care of. So, if you do not have an advance directive, not just a power of attorney, please consider doing so. Um, so emotionally, um, this is something that I had to reconcile within myself, that my father would have wanted me to do, the decisions that I made. And just now I just hope and pray that that's what I did were what he would have wanted done. So, in conclusion, advance directives are a substantial legal way to make sure your wishes are carried out. It should also be noted, again, according to www.ecommunity.com, that an advance directive does not take away your right at all to decide your current health care, as long as you are able mentally and physically to decide your wishes and express those wishes. The purpose of my speech today was to persuade anyone that does not have any kind of an advance directive or healthcare legal documentation in place to please do so. Based on my own personal experiences, government laws, resources, and knowledge that I have presented to you today, I hope that I was able to do so. Not only for yourself, but for your family members as well. My last thought on my final speech is that they are your end of life wishes. They are your choices. Please take the appropriate steps necessary to make sure that they're carried out as you wish. Thank you so much.